Good afternoon, ladies and gentlemen. It's Tuesday, March the 12th, 2024. Welcome to the Civil Justice Subcommittee. Thank you for joining us. Madam Clerk, call the roll.
Good afternoon. Representatives Bolso, Capley,
Yes.
Eldridge, Farmer, Grills, Lamberth, Parkinson, Todd, Chairman Russell. Chairman, you have a quorum.
Thank you, members. We have any personal orders this afternoon. Representative Capley, you're recognized.
Thank you, Mr. Chairman. I got some constituents here from the great Lawrence County. Mr. Lawrence Sutton and his family. Please wave, Lawrence. Everybody give him a round of applause, please.
Any other personal orders? Seeing none, just as a reminder for all members, if you vote in the opposition and wish to have your vote recorded as such, check in with TJ after the vote. Thank you. And we'll start by item number 1, House Bill 2930. We've got a motion and a second, and Representative Garrett, you are recognized.
Thank you, Mr. Chairman. House Bill 2930 is our speaker's bill. He asked me to present that piece of legislation to the committee this morning. And what it is, we appropriated not too long ago $75 million to AOC, our Administrative Office of the Courts. And just so this committee knows, in Tennessee, we have over 300 court systems in this state, and they all operate on different systems. Technically, they can't talk to each other. So what this is, it's going to be a unified court system utilizing that appropriation so we can collect data, be better prepared, et cetera, for cases, so we can create some policy, and also they can talk to each other so they know what we're doing in our court system. So with that, Mr. Chairman, I'll be glad to take any questions. Otherwise, I'll renew my motion.
Thank you. Any questions for the sponsor? Representative Parkinson, you recognize.
Thank you, Mr. Chairman. Sponsor, what's the bill do? Just kidding.
All right. Leader Lamberth, you recognize.
Move previous question.
The previous question's been called. Members, we're voting on House Bill 2930 to send the civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full.
Thank you, Mr. Chairman and committee.
Next up is item number 2, House Bill 2931 by Chairman Howe. Chairman Howe, you're recognized. You're recognized. We got a motion.
Good
and a second,
afternoon,
and I do
committee.
show an amendment.
Thank you, Mr. Chairman. Let's see, let me find it. I don't have the amendment, sir.
I show amendment 015363.
I'm sure that's it.
Motion on
but
the amendment.
somehow
We
it
got a
did not-
motion and a second on the amendment. We're voting to add 015363 to House Bill 2931. All those in favor signify by saying aye. Opposed, no. The ayes prevail. The amendment is attached, and Representative Howe, you are recognized on House Bill 2931 as
Thank you,
amended.
Chairman. I apologize for some reason it did not get put in my packet. But House Bill 2931 is the Speaker's bill. It comes from discovering that there is no paper trail that the Board of Judicial Conduct can refer to when a judge enters into a deferred discipline agreement with the board. In the past, there have been cases where a judge entered into a verbal discipline agreement with the Board of Judicial Review, and then later, as the board moved forward, the judge would deny that they had entered into such a verbal agreement. So this simply just creates a paper trail to allow the board to refer back to when they do have an agreement and have a paper trail.
Very good explanation. And Leader Lambert's got a question for you. Leader
Move
Lambert,
previous question.
and the question's been called. All those in favor of sending House Bill 2931 to civil full signify by saying aye. Opposed, no. The ayes prevail. Civil full.
Thank you,
Congratulations.
Mr. Chairman and committee.
Now, we got a few housekeeping items. Start out with item number 3, House Bill 2825. We're rolling to the April 2nd calendar without objection. Without objection, item number 4, House Bill 1712, rolled to the April 2nd calendar. Item number 8, House Bill 2117, rolled to the Hill without objection. Item number 9, House Bill 2195, without objection, rolled to April 2nd. Item number 10, House Bill 2384, rolled to the Hill without objection. Item number 16, House Bill 2595, taken off notice. Item number 19, House Bill 2648, without objection, rolled to April 2nd. Item number 21, House Bill 2082, without objection, rolled to April 2nd. Item number 22, House Bill 1667, rolled to April 2nd without objection. And that brings us to item number 23, House Bill 2782, taken off notice. Item number 24, House Bill 2136, taken off notice. And that brings us back to okay, members, we're going to take item number 11 out of order. House Bill 2805 by Representative Halsey. We got a motion and a second. Representative Halsey, you are recognized on House Bill 2805, and I do show two amendments.
Thank you, Mr. Chairman. Could we take up 2806 instead of 2805?
Oh, that's a House Bill number, so but, all right, we've already got a motion and a second on this bill number. We can reconsider our actions. Later, Lambert, to recognize.
Mr. Chairman, I make a motion to roll this bill one space.
All right, without objection, rolled one space. That brings us to item number 12, House Bill 2806 by Chairman Halsey. We got a motion? We got a motion and a second. Chairman Halsey, you're recognized on 2806, and I do show an amendment.
Yes, thank you. And the amendment is 014435.
That's what I show. Members, we have a motion and a second on the amendment. We got a motion. We have already adopted it, so it's already on there. So you're recognized on House Bill 2806 as amended.
Thank you, Chairman and Committee, for your indulgence and your patience with me. I appreciate it very much. We met before, as you know, and had several questions about this bill. There is a fear that securities, stocks and bonds could be at risk for Tennessee people with the way the UCC code was rewritten in 1994. And this bill just is an attempt to protect Tennessee people that hold stocks and bonds and those types of securities. And that's the whole intent, is to protect their private property and their assets. And I today have to speak on this issue is Mr. Webb, who flew in here from Sweden just to be with you, and then Don Grandy, who flew in from North Dakota, which they're not just important people, but it shows you that I go for the quality folks. So I just want you to know that. But with your indulgence, if we could go out of session and hear what they have to say.
Absolutely. And without objection, we'll go out of session. And Mr. Grande and Webb, if you all come up to the table. What we'll do is you'll have a seat there. We'll give you each 3 minutes. And once you give your name and title, we'll start the clock, and I'll let you know when your 3 minutes are up. So each of you all have 3 minutes, so begin whenever you like.
Okay.
There should be a little face there with little dots. Yeah.
Okay.
Should be a red light.
There? Yes. Okay. Thank you for the opportunity to be here and speak with you. I'll begin by saying for 400 years, securities were personal property.
Could you identify yourself?
Oh, I'm sorry. My name is David Webb. I am a U.S. citizen. I am now looking at land in Tennessee, but that's another matter. So I'll begin by saying for 400 years, securities were personal property. Now, what that meant was if your account provider, your broker, or your custodian became insolvent, you could take immediate return of your securities. That is no longer the case. Now, you no longer have property rights to securities. What you have is a newly created concept implemented through the Uniform Commercial Code of a security entitlement. This is not a direct property right. This is a contractual claim to your own property that is very weak in the event of insolvency. The other thing that's very important is that all securities are held in these massive pools, in pooled form at a higher level. They are not legally held at your broker, your custodian. They are held in massive pools at Depository Trust Corp. Now, the securities in these pools, because there's no specific identification of the investor to any security, they're not numbered. These pools are available for the securities industry to use without restriction for proprietary trading within the securities complex, within the industry. So what the situation is that people can be told that their securities are segregated at the broker level. It's just in the books and records of the broker. The subterfuge is that they are being used at a higher level in the system, where the secured creditors actually have ownership over the securities. Now, how do we know this? We know this irrefutably because the Deputy General Counsel of the New York Federal Reserve responded to a questionnaire from something called the EU Legal Certainty Group, so it was a formal legal response that explains the operation of the UCC. So this is not conjecture. It's from the highest source possible explaining how this works. And the Fed makes it clear that even segregated.
Mr. Webb, that's your 3 minutes. So we'll get we'll take Mr. Grande's and then we'll take questions after he gets there. If it's just hang in there for me for 3 minutes. Mr. Grande, if you'll just identify yourself and you'll have 3 minutes.
My name is Don Grandy. I am a private practice attorney and been working on this issue for quite a while with regard to the Uniform Commercial Code and more specifically to this issue. So in a nutshell, as Mr. Webb has talked about, with the 1994 Article 8 revision, they conjured a new type of property ownership or property right called a securities entitlement. The drafting committee defines a securities entitlement as a bundle of personal rights you hold against your broker. So if I hold rights against someone else, that's a contract. So it isn't a security in the sense that you thought you used to own something on paper. It's a contract, and any discussion to the contrary is false, and it's right there in the current UCC. So what this bill is targeted to do is remove two exceptions that give the secured creditors, banks, the largest banks, who have lent money to your broker or a custodian. There's two exceptions in your current statute that give those lenders priority to the investor's assets in an insolvency situation. So without the knowledge and consent of the investors of Tennessee, they could lose their securities entitlement, which is tied to the security they thought they bought, but that's a different issue. So they can lose their security entitlement to this bank, this creditor, to pay the debt of somebody else that the investor didn't even know about, didn't consent to. And so we just fundamentally think that's wrong. We think there's additional things that we need to look at, but first and foremost, we just want to restore some property rights to the people of Tennessee. And that's sort of the summation, so we'd be happy to answer any questions. I'm assuming there are some.
Thank you. And members, we got one on the list so far, and Representative Parkinson, you're recognized for Mr. Grande or Mr. Webb.
Thank you. Which is which again? I'm sorry. Grande? Webb, okay, all right.
And
okay.
Mr. Webb, just make sure
Right.
your red light's on again.
Yeah, thank you. And I'm not going to try to figure out who's from South Dakota or North Dakota and who's from Sweden. Take it for the team, but I do have a question, but after I finish the question, I do want you to finish your explaining everything. I think it's important for the people. I honestly think it's important for the people of the country to hear what you're saying, because it was all new to me and a shock to me. When I heard testimony the first time, being a person that has invested in stocks, and to learn that the only thing I have is entitlement to what I spent money on. But what I want to know is this: at that higher level, where the pool of the properties are, what are they doing with those? What are they doing with that? Are they making money off of that? That's what I want to know.
It's use of the securities as collateral without restriction. So now this change in the UCC was in '94. It took a number of years for it to be implemented in all 50 states. Coincident with that, we saw the massive growth in the derivatives complex. Now, a derivative, it's kind of an intimidating word. What's a derivative? A derivative is just a contract written describing the behavior of something else. So derivative instruments always were contracts that would have had a weak standing in an insolvency. And what's been done here is to take what had been property, where people could have gotten it's called revindication, taken back their own securities. Those are now contractual claims, but the collateral is being used within the derivatives complex. And those were contracts, but the secured creditors there now have what's called super priority to those pooled assets. And it's only the biggest banks that have this super priority to take the assets out of these pools. And what we see from this Fed response to the legal certainty group is that the public only gets what's left in the pool after the secured creditors have taken from the pool. And it's very important for people to understand that this is not just individual investors. Think pension funds, investment funds. It includes the biggest, most sophisticated investors. They are told, they want to believe, and they want to believe they can tell their clients that their accounts are segregated. This Fed response makes it clear that that is not operational in the event of insolvency, which is exactly when you would need to have it. So how were they making money out of this? Well, the derivatives complex by a little after 2000 had reached $110 trillion. That was about twice the size of global GDP. So this, by 2007, the financial crisis that was developing then, derivatives had reached 700 trillion. So it had gone from 100 to 700 trillion in 5 years. It's now estimated to be maybe 20 trillion or 2 quadrillion, which is about 20 times the size of global GDP. Now, what made that possible was using these vast pools of the client assets as the collateral that is extended under these basically bets, these contracts. And so they're using someone else's collateral for their trades. And that's what has facilitated this massive global bubble that we're in. So what we're talking about here, have they made money through that? Yes, but it's about power and control. It is, and they're not going to tell you about this. They're the last people that are going to tell you about this, because they are benefiting from using this resource of the public without restriction. And also they have this term FOP, which means free of payment. They can use the collateral from these pools free of payment.
Mm.
And y'all are welcome to go back and forth.
Okay. Thank you, Mr. Chair. I didn't even know quadrillion was actually a real word. I thought it was something I made up when I was 7, but but apparently it is.
It is
But
now.
it's really first of all, this is one of the most interesting conversations we've had in this committee to me. Secondly, it's shameful that these things happen and the general public think that they're doing something to secure a legacy for their families, and even at that level they're still being used in a herd mentality, so to speak, right, to be exploited without them even knowing that they're being exploited, and without even receiving benefit for the use of what is their property.
Yes.
And so, but I thank you for your testimony. It's incredibly enlightening, and truly appreciate you being here, and you as well, sir.
Thank you.
Representative Bolzo, you're recognized.
Thank you, Mr. Chairman, and thank you, Mr. Webb and Mr. Grandy, for being here. I've got, questions that fall into 3 categories. One is to understand what the bill does. Number 2, to understand what the concern is that has raised the need for the bill. And third, to try to understand whether the remedy actually addresses the concern. So first, with regard to the bill itself, is it accurate to say, Mr. Webb, that what the bill does is to reverse priority between the entitlement holder and the secured creditor in the event of the insolvency of the securities intermediary?
Yes, to make it clear that the investor has priority in the event of insolvency to the entitlement. Yes.
Okay. So that
It's
seems
as
like
clear as that. It's as simple as that. May I say more about
Sure.
that? Okay, so the way this was implemented in the UCC, there's a clear statement that the entitlement holders have priority over secured creditors. And for example, in South Dakota, this is what was read by the banking lobbyists, and they just stopped there. There's an exception. It then says except. So you then go to the next paragraph, and it says the same thing, that the entitlement holder has priority. And then there's another except. You have to go down 3 paragraphs, and then you see how it actually works. The exception is that if the creditor has control over the security, the creditor always has priority. Now, in an indirect holding system, it is easily done and always done for control to be achieved by other parties than the investor. This is an aspect, or this was made possible through dematerializing securities, going to an indirect holding system, a book entry system. When we had certificates, there was a bright line as to who had control. To give control to the broker, you had to formally sign that over. There had to be an agreement to sign it over. By dematerializing and holding the securities in these pools on a vast scale, it made it unclear who had control. So the industry developed the practice of using this resource without the knowledge of the public. And the amendment to the UCC in '94 was to make legal what they were already doing. So this approach, which Don has crafted, is simple and elegant. It is simply to strike the exceptions. So there's a full stop at saying that the entitlement holder has priority. Now, it's still an entitlement. We haven't gotten all the way back to property, but it at least restores clearly priority. Now, nothing should change at all. There's fear-mongering that if you make this change, it will be bad for business somehow. You really have to question that. Of course, they don't want you to know about this or to address it. Nothing should change if you change this. It only comes into play in the event of large-scale insolvency. And then you absolutely want to have made this change. And frankly, the reverse, keeping it, is absolutely indefensible. Why should secured creditors have priority over the assets of the public, and when the public is not borrowing against that? This is what we have to understand. It's someone else that is encumbering that asset. The public owning assets free and clear without debt they are vulnerable to this through this subterfuge.
And so if I understand the concern, it is that at some point in the future, one or more securities intermediaries may become insolvent. Is that right?
This is the major concern.
Okay. And
Yes.
an example of a securities intermediary would be a clearing broker dealer.
This is one of the exceptions here as well that's very important. A clearing entity, the creditors of a clearing entity always have priority to the pooled client assets. So yes, the failure of a clearing entity will trigger this. Now, let me say further, what was done in the last financial crisis, an imperative was created to centrally clear all derivatives. So it used to be that derivative contracts were things like a farmer selling the crops forward at harvest time. And so the farmer was happy to sell at that price at that time. There was a party on the other side that wanted to buy the crop at that time. There was a real purpose to these contracts. They were bilateral. There was a party on both sides. The 2008 financial crisis was used to say, that's too risky, that you have a counterparty. We're going to centrally clear these things. Now, what that means is that your counterparty is the central clearing counterparty. And we have analyzed this. The central clearing counterparties are very thinly capitalized. DTC itself, which houses all securities for the US, it operates two of the major central clearing counterparties. The total capitalization is a little over $2 billion. That is nothing in the scheme of things. And DTCC itself is planning to start up and pre-fund a new central clearing counterparty when one of the existing ones fails. The industry is talking about the very real possibility that major central clearing counterparties will fail. They are preparing for it.
All right. But an example of a clearing broker dealer would be UBS or Charles Schwab or Raymond James or Merrill Lynch.
A broker dealer.
A broker
But
dealer.
at this higher level, they are, let's say at the top of the food chain is DTCC and the central clearing counterparties in the derivatives complex. That's where these vast pools of collateral are being used.
So DTC has possession of the personal property.
Yes.
Is that correct? All right.
Yes.
And an investor doesn't have an agreement with DTC. An investor has an agreement with a clearing broker dealer.
Yes.
And that account agreement likely contains a choice of law provision. Would that be true?
Yes.
And do you know typically what law's form is chosen in a choice of law provision in an account opening agreement?
Well, this is an important concept because the ancient principle, I've been through this in Europe as well. The ancient principle was that the law of the place of the property governed. So where the client was, where the property was governed. But in order to allow the transport of this collateral cross-border, that had to be subverted. And this is a fairly recent change, both in the US and then later in Europe, quite recently in Europe. So it's now been done globally. And this place of law is a very important issue because the place of law can be set where the central clearing counterparty is, for example. or where the securities, the higher level pooling of securities, where that resides. So it is a crucial issue, and it's something addressed in this bill, is to make the place of law the state of Tennessee.
Is there language in the bill that does that?
Don,
Mr. Chairman, Representative, yes, there is language in the bill. I believe sections 1 and 4 would deal with jurisdiction. The current Article 8 breaks jurisdiction down into a couple of different steps. One deals with issuers, like that companies that issue stock. We don't deal with that in this bill. We don't have any issues with that. In that situation, the jurisdiction is in the issuer's jurisdiction, which makes sense because that's the entity they're organized under those state laws. The second one, and I'm 8103 or 8105, I'm blanking a little bit on the section. The second jurisdiction provision deals with the choice of law jurisdiction between a entitlement holder, which is an investor in normal people language. So between the investor and the securities intermediary, it's in the securities intermediary's domicile. The securities intermediary would be your broker, the broker's custodian, the custodian's custodian, up the chain. So this bill would say, if there is going to be a fight over my property as an investor, we're at least going to have a fight here in Tennessee.
Well, and let me ask you to follow up on that, Mr. Grandy. If a Tennessee investor has signed an account opening agreement that specifies that New York law is the law that governs the relationship, is there any effect that this amendment under Tennessee's version of Article 8 would have on that investor's relationship with his clearing broker dealer?
I believe the answer is yes, and I can follow up with you on that. Right before this hearing, I received an opinion that was just issued this week in New York court, because this is the state law we're talking about here. So there was just an opinion issued, and it was dealing with that issuer's jurisdiction, and it said that the state law that UCC controls. So if your UCC says Tennessee, then that controls. But I'm that was my read, a quick read over lunch of that opinion. I'll be happy to forward it to you.
Is DTC located in New York?
yes.
Yes.
Okay. And do we have any decisions that address the question of the situs of personal property of the nature that we're talking about? Because before a court could enter an order affecting anyone's rights in property, real or personal, the court has to have jurisdiction of the property. That's easy when it's real property because it's in
Yes.
Tennessee or it's somewhere else. But here we're dealing with intangible property rights.
Yes.
Are you aware of any authorities that deal with that issue?
This issue, you're getting to what's the nature of a securities entitlement, and is that considered property enough to give situs to the state of Tennessee? Those issues have not been explored yet, that I'm aware of.
Thank you, Mr. Chairman.
Thank you. And just to clarify, before 1994, much didn't change in 94. Just had them doing what they was doing prior to 94. Is that correct?
Yes, I would say that the practice, they were basically papering the practice that they were also using these securities. But once it was implemented in all 50 states, what I'm pointing to is that's when there was the dramatic escalation in the use of the pooled securities underpinning the derivatives complex. So they were coincident. You know, it was being used quietly, but then once it was solidly legal for them to do this, it was done on a epic scale.
And if I understand you right, if this bill goes into law, it would protect the individual investors.
Also, very importantly, institutional investors.
Okay.
This is, in terms of real asset protection, this is an enormous issue that is important for the financial services industry. So it is it is misleading to suggest that this is bad for business. If you provide real asset protection and you protect your financial services industry in the state, really, the other way to look at this is if the people in the financial services industry are vulnerable to the liability of this. They are being set up to be the first line of exposure to displeasure on the part of the public. So it's ultimately will be very important for the financial services industry in Tennessee and hopefully in other states to do this to provide real asset protection. And I can tell you, there are people around the world that are watching this because this will be very important to them. As there are a lot of people that are now aware of this issue globally and are trying to find a solution for a safe venue.
And can you think of any particular incidents recently where this law would have came beneficial for somebody?
Where it would have been beneficial, well, I can go into where the experience we have where we see how this operates, and it was the current situation damaged people. The most important case was Lehman Brothers, the failure of Lehman Brothers. This was really the test case for this. And in this instance, institutional clients had collateral, dry powder, so to speak. They were not using this collateral. You're in the middle of a terrible financial collapse. Lehman Brothers fails, and it turns out that Lehman Brothers had encumbered the collateral of their institutional clients. These institutions did not recover access to that for over 5 years. So if you imagine you're in the middle of a crisis and you lose access to the collateral because your own custodian was using your collateral. This is what happened in Lehman Brothers is that JP Morgan was the custodian for client assets and also the secured creditor that took the client assets. And that is no longer fraud to do that. So we see people who really understand this have a real urgency to figure out a way to really achieve protection, and that would be the benefit. It's actually shockingly simple. The thing I say is just give people back their stuff. It's as simple as that. Having real direct property rights protects you from insolvency. That's why they were called securities.
Very good. And we don't have anybody else on our list, but we appreciate both of y'all for being here. Thank you. We got two
Thank
more
you.
people here to testify today. Andrew Guggenheim, I think is how you pronounce that, and Timothy Amos. And if you both will have a seat there, just make sure your red light's on. Just say who you are, who you're with, and as soon as you start talking, we'll start timing, and you both will have 3 minutes each.
All right, thank you, Mr. Chairman and members of the committee. My name is Andy Guggenheim. I'm with the Securities Industry and Financial Markets Association. We are a national trade association representing broker-dealers, investment banks, and asset managers, many of whom have a presence in Tennessee. In fact, roughly 130,000 people work in the finance and insurance industry in Tennessee. There's about 1,300 securities firms and 42 broker-dealer main offices. The U.S. equity markets are incredibly efficient and resilient. Investors now have the greatest ease of access, lowest cost of trading, and best execution in history. These markets are successful in part due to the state and federal laws that work in concert to provide customers with easy access to their brokerage account as well as the ability to buy and sell securities. Article 8 of the UCC was drafted in the 1940s, updated in the 50s, 1978, and 1994. This law, which underpins securities transactions at the state level, has been adopted in all 50 states. There's also a process for amending the UCC by going through the Uniform Law Commission. I'm sure Tim will address that in just a moment. But what this law does is it helps facilitate trading and holding of securities. Among other provisions relating to the holding and transfer of investment securities, this law allows owners of securities to hold those securities either directly that's in their own name, or indirectly, which is referred to as street name. As technology has evolved, most customers have opted to hold securities electronically with their brokers, as paper has been phased out in most industries. While holding securities in street name is the most common choice for investors, they do have alternatives for holding securities in other ways if they prefer, including physical form via stock certificate when that's available by the issuing company. But regardless of whether ownership is demonstrated via electronic certificate or on paper, a customer's property rights remain the same. Many investors find that holding securities in street names offers substantial advantages in terms of market access, efficiency, security, and cost. As a result, the majority of retail investors choose street name for their holding. Holding in street name allows investors to buy and sell securities more quickly and efficiently, resulting in lower transaction costs, greater savings, and the ability to execute trades more quickly. Customers who hold securities in street name can also take advantage of much of other services provided by their brokers if they choose, such as the ability to set a price for which to buy or sell a security, or to offer their securities as collateral for margin loans at their broker for, or at borrowing for banks. However, this ability is grounded in the law governing security interests and in no way diminishes a customer's ownership rights. Investors who hold securities in street name with their brokers are protected by a range of regulations dedicated to ensuring that client assets are appropriately controlled and segregated from the assets of their broker. These securities cannot be borrowed.
Mr. Amos, that's your 3 minutes, and Representative Parkinson, after Mr. Guggenheim does his, we'll take questions. Mr. Guggenheim, if you'll just identify yourself and who you're with, and I'm sorry, I got you backwards. Mr. Amos, if you'll
Yeah, thank you,
identify yourself.
Mr. Chairman, members of the committee. My name is Tim Amos. I'm an attorney here in Tennessee, and I'm one of Tennessee's 5 uniform law commissioners. And I would address a couple of things here. First off, this would create a non-uniform provision, which I think would be detrimental to the state of Tennessee. And the regulation of investors and protection of investors is not exclusively the jurisdiction of Tennessee. In fact, our jurisdiction is fairly limited compared to the rights and protections that are in place by the Securities and Exchange Commission. This legislation seeks to change a couple of things that I think are very detrimental. The first, Representative Uso, goes to the issue of jurisdiction. To make this law or this change stick, basically you've taken away the contract rights to select the jurisdiction. That's the first thing that this bill does. It requires that any account held by a consumer or an investor in the state of Tennessee would be governed by Tennessee law and would not be subject to the ability to have a choice of law provision. As you would know, most securities broker dealers would choose the law of the home. That's the default that's actually in the current statute that's being taken away, because as a business, you can't run a business if you have to keep up with 50 different state laws in 50 different states, particularly in the securities industry that is nationwide. You need a new uniform set of laws, and they need to stay uniform. So that's the first negative in the bill. The second negative, and I think it's a little bit incorrect, is yes, in terms of priority, the priority section in virtually all instances gives the account holder the priority. The 2 exceptions, which they are removing, which they did acknowledge. The first exception is where the consumer actively agrees to pledge his securities for a loan to buy the securities. That's called a margin account. This legislation takes away that priority and thus would effectively prevent any consumer in Tennessee from having a margin account. The second place where the statute takes away again, a right of a consumer is where the consumer takes and actively authorizes the securities broker dealer to lend, which they do, the securities to other folks, and for which the consumer gets a fee. So both of the exceptions in the statute that they're trying to remove are instances where the consumer has actively consented to those exceptions. Otherwise, the statute provides absolute priority for the consumer. The other point that I would make is federal law, when you provide securities and they're held by a securities intermediary, the securities intermediary 100% of those securities in an account in your name. So yes, maybe it's called an entitlement right, and maybe it's held by the DTC, which is really a trust company. It's held in trust. The consumer's account.
Thank you for your testimony. We've got unlimited time for questions, and first up is Representative Parkinson.
Thank you, Mr. Chair. The DTC is well, two things. One, where is it that and good to see you, first of all. Right. Yeah. Where is it that the consumer gives consent? In the fine print that nobody ever reads? Is that where that happens at? Hit your button.
Make sure your mic. Yeah.
Yes, it would be in your securities account agreement when you. I've gotten some of these, and yes, they're about 20 pages long of a lot of fine print. But yes, if you want to have your securities and you hold them in what it's called street name, then yes, you would agree that the account is in your name and that your securities held in street name would be held by the DTC trust company. If you're a consumer and you go to the broker dealer and you want a security, they can print you a security. Now, that comes with some downsides, meaning if you want to sell it tomorrow, you have a real problem. You have to send in the security and transfer it for next week or the week after. So most people have opted, and by consent, to have their securities held in street name because it makes it more efficient for them to manage the securities, or for that matter, for your investment advisor to manage your securities on your behalf.
And y'all are free to go back and forth.
Okay, thank you. Yeah, man, we can talk about children and everything since we're free to go back and forth. But I'm just kidding. So street name is that a term for electronically held?
That would probably be the common parlance for what we're talking about is a securities entitlement.
Okay. Thank you. That's all I need. Thank you.
Thank you. And Representative Bolzo, you're recognized.
Thank you, Mr. Chairman. Mr. Guggenheim, let me give you an opportunity to respond to some of the points that Mr. Webb and Mr. Grandy made. You likely heard Mr. Webb tell us a little while ago that for 400 years, securities were personal property. You started off some of your testimony by saying that the property rights remain the same. So those two statements strike me as being inconsistent. Can you tell us whether you agree that those two statements are inconsistent? And if so, which one is the accurate one?
Well, quite frankly, I don't think we have peace in the valley on whether this is, whether we don't really see eye to eye on this point. I think you hold the security, you hold it differently. The SEC and FINRA have put out notices about how you can hold your securities. You can hold them through street name. You can hold them through several other methods, including paper certificates. But your ownership rights remain the same. And to Mr. Amos's point about collateral, that's when your property rights change, is when you offer your securities as collateral for a margin loan.
Mr. Webb has told us, though, that the securities that many Tennessee investors believe that they own as personal property are actually being pledged by others to secure indebtedness of securities intermediaries. Do you agree or disagree with that testimony?
Disagree.
Why is that?
Because this relates to the security interest for a margin loan. So I would look at this as the way you look at collateral for any other loan. This is when you use your securities as collateral. That's when your property rights change.
Now, Mr. Amos, you mentioned something about margin accounts, and that, as I understand it, this bill would flip the priority with regard to margin accounts. If this bill were enacted, how would a Tennessee investor who has a margin account be affected either adversely or positively?
Well, I think the short answer is if you had an existing account, I'm not sure how that you would unwind that. Certainly going forward, this would not permit you to create a margin account unless there were a lender out there who was willing to lend against your securities without taking the securities as collateral. Maybe they could take some other collateral like your house or some other personal property, but they certainly under this bill would not be able to use the securities themselves as the collateral for that loan.
Thank you, Mr. Chairman. Thank you.
Thank you. And Representative Parkinson, you're next.
Thank you, Mr. Chair. And I just want to follow up on with Mr. Goop. I'm about to jack your name up. So
That's,
let me try to get this right. Mr. Guggenheim.
that's you
I was
nailed
about to
it.
call you Google and Heim but my question to you is this. So are the brokers not using the purchased assets as collateral?
It would only apply in the case of a margin loan where the broker has that security interest and then can use that. That's what this provision was designed for in the UCC. But in terms of just taking a security and using it without the for a margin loan, then or without that context, that's not my understanding.
Can you say that so a fifth grader can understand it, so I can understand it, if you don't mind? So are they? I'm just want to be clear. Are they using the purchased assets as collateral, or are they not using it as collateral?
So if I had change in my pocket, I wouldn't know the exact quarters. I would know that I own this many quarters in my pocket, but whether that, so kind of getting it down to that level of which security it is, you own securities, you own, the number that says on your brokerage statement, whether it's this security, but you still hold those same voting rights for your ownership stake in those securities, but securities, can be are more fungible in that respect.
So I think I'm a little clear now. So I think you are, and I don't want to speak for you, but I just want to regurgitate what I think I'm hearing. So given the fact that these securities are in a pool, they are using the securities in the pool as collateral, but you don't know necessarily if they're using yours or somebody else's.
That's my understanding. Yes.
That's how a fifth
Yes,
grader would
yes.
understand it. Right, you're speaking bank to me, and I need you to speak.
I only
Right.
have a kindergartner in the first grade, so we haven't gotten to fifth grade
Right.
yet.
But so there is then a great possibility that they could be using your assets as collateral in whatever business they're doing. Nobody knows if it's yours or if it's someone else's, but somebody's is being used as collateral with the brokers then, correct?
I guess I would go back to you have the ownership stake, on the basis of those securities, and that's kind of the plumbing of the financial system that kind of allows for the benefits of easy access to trading and having a kind of a very liquid market.
Okay, thank you.
Thank you. And I don't have anyone else on my list. So without objection, we'll go back in session. We appreciate y'all being here today. Thank you.
Thank you.
That brings us back to the sponsor. Chairman Halsey, you're recognized.
Thank you, Chairman. Thank you, committee. At the end of the day, this bill just does two things. If you're going to have to sue to get your money back, whether it's in a pool, a big pool, a small pool, or any pool, and they've used your money as collateral on a loan, now the big bank wants to pull it in, this bill just says, instead of the bank being at the top of the priority list of getting your money, you go to the top of the list. The second thing it does is if you have to sue to get your money back, you're going to be able to do it in the state of Tennessee instead of the state of Rhode Island, New York. Now, that's about it. At the end of the day, you got to decide how much risk Tennessee people are up against. And if passing this bill will help protect them, then I think that's what you ought to do. And I think you ought to wait till Gino Bolso gets back if he's going to vote for it. If he ain't going to vote for it, then just leave him out there. That's all.
Representative Parkinson, you're recognized.
Thank you, Mr. Chair. Mr. Chair, was there an amendment on this bill?
They was, and it was traveling with it, so it's already on there.
Oh, okay. Can I get a roll call vote on this bill?
I don't have a problem with the roll call vote, so
Okay. Thank you. We hadn't voted.
thank you. So,
By the way,
Ask for a roll call vote.
one
Mr.
other
Sponsor.
point, if I can make it. Mr. Webb, you've seen him before. He wrote the book, The Great Taking, that you've probably heard a great deal about. And I just want to say publicly, thank you for making a trip from Sweden to be here. So
thank you. And not seeing any other names on my list, members we're fixing to vote, and Madam Clerk, take the vote.
Representatives Bolso, Capley, Eldridge. Eldridge, yes? I'm sorry. Farmer? Yes. Farmer, yes. Grills?
Yes.
Grills, yes. Lamberth? Lamberth, no. Parkinson?
Yes.
Parkinson, yes. Todd? Todd, yes. Chairman Russell?
Aye.
Chairman Russell, aye. Chairman, you have 6 ayes and 1 no.
All right, the ayes prevail. House Bill 2806, civil full. And Mr. Sponsor, thank you for standing up for the little man.
thank you, Chairman and Committee, and thanks for working with me. I appreciate it.
All right, Chairman, we've got one more for you. Item number 11, House Bill 2805. Do we have a motion? We got a motion and do we got a second? We got a second. Chairman Halsey, you're recognized on House Bill 2805, and I show 2 amendments.
Thank you. I appreciate your indulgence. Is Catherine here? Right here. I would like, if you could, she's on the list, to go out and let her talk for 3 minutes. And I promise you, I'm going to make a recommendation for you to send this to a serious summer study, but I want you to hear what she's got to say. And so I appreciate that.
Members, without objection, we'll go out of session. And Ms. Fritz, you'll have 3 minutes. If you'll just identify yourself, who you're with, and as soon as you start talking, we'll start timing. Just make sure your red light's on.
Okay, yes, sir. Chairman Russell and members of the House Civil Justice Subcommittee, thank you for the opportunity to speak to you today on House Bill 2805. My name is Catherine Austin Fitz. I live in Hickory Valley in Hardeman County, which is House District 80. I published the Solari Report, and I'm the managing member of Solari Investment Screens. During the first Bush administration, I served as the Assistant Secretary of Housing, Federal Housing Commissioner at the U.S. Department of Housing. And subsequently, my company served as lead financial advisor to the Federal Housing Administration. House Bill 2805 reflects a potential response to an ongoing deterioration in the federal finances. The current federal debt now stands at nearly $35 trillion. It's rising approximately $1 trillion every 100 days. In periods of financial stress, such as this, national governments often reduce their citizens' income. They limit income or access to use of cash and deposits. We've had the U.S. and global central banks imply that they intend to significantly control our currency system and change our currency system. As a result, there is a potential significant transfer of wealth, including of land and real estate. It happened in the United States during the Depression. It happened in Latin America in the last several decades. It happened in Eastern Europe after the Berlin Wall came down in 1989, and it happened during the COVID period when millions of businesses on Main Street were deemed to be non-essential, and businesses that were resided on Wall Street were deemed to be essential. House Bill number 2805 authorizes the governor to implement a mortgage on mortgage foreclosures under such circumstances in an action that would prevent taking of thousands of Tennessee properties. It also authorizes the Attorney General to implement a series of supporting actions. We hope such a moratorium is never required or reached. However, given the deterioration in the federal finances and the implementation or the suggestion by the central bankers that they intend to insert or institute central financial transaction control, a prudent man would be prepared to protect residents against this kind of disaster capitalism. This includes you, your family, your neighbors, and constituents. Thank you for the opportunity to address the subcommittee. I'm happy to answer any questions.
Thank you, Ms. Fitz. And Representative Bolzo, you're number one on my list.
Thank you, Mr. Chairman. Thank you, Ms. Fitz, for being here. My question is a very basic one. Obviously, every bill that we pass must be constitutional. And we do have Article 1, Section 20 of our Constitution that forbids us to pass a law that impairs the obligations of contract. And if I understand what this bill does, it authorizes the governor to impair contracts of parties to mortgage agreements. How is it that any member could vote in favor of this legislation, given that it violates Article 1, Section 20 of the Constitution?
So I think that's an excellent point, and it's one of the reasons we'd like to see the bill go to, I think Representative Halsey would like to see the bill go to summer study. However, we are only contemplating this in situations where the citizens or the residents of Tennessee in question have experienced significant, and I would say unconstitutional abrogation of obligations and lawlessness towards them. And one of the questions for summer study is whether you can bifurcate the mortgages or use offsets on mortgages in a way that will protect the constitutional provisions of the Tennessee Constitution, but still address the potential sort of taking of the, or potential taking of the residents' land and assets.
Thank you. Members, we have any other questions, Ms. Fitz? And seeing none, we appreciate you being here. Hopefully you find us more effective and efficient than the federal government. So without objection, we'll go back in session. And Mr. Sponsor, just to clarify, you're not considering any amendments since you're sending this to summer study?
That's correct.
Okay, you're recognized.
Thank you very much. And thanks again for your time and your indulgence here. I think when you talk to serious financial folks, you can see the train going down the track and you can see there's a big wreck coming. It's just how do we prepare ourselves and get ready for it? And that's the whole motive behind this bill. So I do look forward to a summer study on it.
All right, members without objection, we're going to send House Bill 2805 to summer study for a complete and thorough study. Thank you, Mr. Sponsor.
Thank you so much.
Thank you. Is Representative Miller in the room? All right, without objection, we're going to roll item number 5, House Bill 2449, 4 spots. Brings us to item number 6, House Bill 2839 by Representative Towns. We got a motion and a second. Representative Towns, you are recognized on House Bill 2839. I do not show any amendments.
And members, there are no amendments, Mr. Chairman. I will say that the bill actually did so well on the Senate side that it's already passed on consent. Let me see, hold on. Which one is that one? Which one is that?
Well, you're number 6, House Bill 2839.
That 2830, let me make sure. This is one's already passed on consent.
This one shows judiciary in the Senate on March the 11th. And it passed yesterday.
Okay. Let me make sure I got the right one, sir. I won't tell you anything wrong. I had it just a moment ago. Sorry, committee.
Chairman Farmer, you're recognized.
Yeah, Mr. Chair, thank you. And hey, Representative Towns, I have a question. I had, I followed a little bit of the Senate committee yesterday, I believe it was. And it seemed like they had some folks there to testify. Do you think that maybe you would like to have, maybe roll this a week and see if they could come? And because it seemed to get kind of down in some unique issues of law and this, that, and the other in regards to IRAs and some other things. You think you could arrange that maybe for next week? Would that be helpful?
Mr. Chairman, I would, and I had the wrong bill number. You're absolutely correct. I do want to roll it. I'm looking at the other bill at 28.
Without objection, could we
Yes,
roll
sir.
it to the Hill? Because this is the final calendar.
Oh, wow.
All right, without objection, item number 6, House Bill 2839, roll to the Hill.
Okay. Mr. Chairman.
Yes, sir.
Is 2864 on your list?
Um,
That's the one I thought it was. I'm sorry.
That would be in Public Service Subcommittee.
It's in public service. They have it listed here as silver. Okay.
Everybody's trying to get into this committee. It's so good. So,
Right. I'm wrong. Go ahead.
Yeah. Leader Lambert?
Representative, did you say House Bill 2864? I believe that's the one that designates barbecue
That's
as an
correct.
official state food. That's not for this committee, but it sounds like a dang fine job. I mean,
Representative Parkinson?
Thank you, Mr. Chair. If that's the bill, that should be on consent.
Yes, sir.
That's what I was about to say. It was on consent on the other side over there. So, but I got it listed wrong here. Okay.
So you come back here anytime. Bring some barbecue. All right, that brings us to item number 7, House Bill 2282 by Representative Hawk. And we'll roll his 5 spaces. Brings us to item number 13, House Bill 2372 by Chairman Terry. We got a motion and we don't have a Chairman Terry. Leader Lambert?
Mr. Chair, if I could roll that 4 spaces, please make a motion to roll 4 spaces.
Okay, we're going to roll items number 13 and 14 without objection, 4 spaces. Brings us to item number 15, House Bill 2604. Leader Lambert.
Make a motion to return to the clerk's desk.
All right, we got a motion and a second. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Clerk's desk. Number 16's been taken off notice. That brings us to item number 17, House Bill 2047. We got a motion and a second. And Representative Carringer, you are recognized, and I do not show any amendments.
That is correct. Thank you all. I feel like the lucky winner today for change. So
You're recognized.
okay, I just wanted to make sure you were ready. Okay, thank you, Chairman and committee. House Bill 2047. Some of y'all were probably here a few years ago when they did this original bill, but this was brought to me to also include. They left out former public officials to the list of officials who may contest liens on real property believed to lack any legal basis. So essentially, this is a really simple bill that's just clarifying and adding former public officials to our state law as it is now. So with that, I'll stand for questions and ask for your support on the bill.
Very good explanation. Members, we have any questions for the sponsor? And Representative Todd, recognized.
Thank you, Mr. Chairman. Can you give us an example of how this would work if this is passed? Kind of walk us through a real life scenario, please.
Representative Carringer, and you're all were welcome to go back and forth.
Thank you, Chairman Todd. So according to the Tennessee Code 66-21105, an individual who is a current or retired elected or appointed government official, including state, county, metropolitan, or municipal officials, may contest a lien or other encumbrance relating to real property that the public official believes was filed without a reasonable basis. So they could come in. So whereas you're an elected now, you're safe, but it doesn't keep them from going back and going after former elected people on being able to put liens or anything on your property that you may own. As far as a particular instant, I don't exactly know of one. I figured there's probably been somewhere across the state, or this bill would not have been brought to me to address to make sure that we add the former public officials onto it.
I'm just still trying to figure out what world this is in. If you can narrow this down for me, liens and former officials, and I'm just not following where this is fitting into everyday life. And I sincerely mean that. I'm just trying to
Yeah.
understand what realm we're talking about here.
And to the sponsor, this is just for Knox County, is that correct?
No,
It's statewide?
this would be statewide.
Okay, I apologize.
Yes. And do we need to have legal or is that?
I think I understand this a little better now. Just one of those things I'm just not aware of, haven't been aware of. So
Yeah. And I'll have to tell you, I wasn't either. And so without going too much, I'll leave that to the ones who are more familiar with it, which would be legal if we needed to go there.
All right, I don't see any other questions. Without objection, we're going to be voting on House Bill 2047 to send to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. That brings us number 18, House Bill 2360. We had a motion and a second, and Representative Carringer, you're recognized.
Thank you, Chairman and Committee. And yes, this does just deal with Knox County at the moment. So House Bill 2360 was also brought to me. It has already passed in the Senate, and they're waiting on us. So Knox County General Session judges, our Knox County Commission appoints our general or magistrates. So this would take and make the appointment process for Knox County General Sessions magistrates. Also would supervise the chain of command for Knox County General Sessions magistrates and the term of service of Knox County General Sessions magistrates. So where our judges would bring, when we had a vacancy as for a magistrate in Knox County, our judges would bring the person that they were recommending, and county commission would vote and appoint the person that they would recommend. So, and then there's been some questions as to who they really work for. Do they work for our judges, an answer, or do they work for our commission? And obviously, they work for our judges. So this is just to make that law for Knox County. So that I'll stand for any questions.
Very good. I don't see anybody requesting a question, so we'll vote to send House Bill 2360 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail.
Thank you very much.
You're welcome. Members, that's without objection, we'll go to item number 13, House Bill 2372 by Representative Terry. We got a motion and a second, and Representative Terry, you're recognized. I do show an amendment.
Yes, thank you, Chairman. Committee Amendment 14730.
That's what I show. We got a motion and a second on the amendment. Members, we're voting to add 14730 to House Bill 2372. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Representative Terry, you're recognized on the bill as amended.
Thank you, Chairman and Committee. And this bill would ensure that General Sessions judges' compensation beginning September 2030 will be tied to the Consumer Price Index, will still be capped at 4%.
Very good explanation. Members, do we have any questions for Representative Terry? Seeing none, we're voting to send House Bill 2372 to full civil. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full.
Thank you.
Brings us to number 14, House Bill 2434 by Chairman Terry. We got a motion and a second, and I do show an amendment, but we're going to have to reconsider our actions to take off the previously adopted amendment. So okay, so this rewrites the bill, is that
Yes.
correct? Okay, members, so what we're going to do is, do we have a motion and a second on House, or make sure I got this right, Amendment 015126. We do have a motion and a second. Without objection, well, all those in favor signify by saying aye. Opposed, no. The ayes prevail. All right, so that rewrites the bill, and I believe we have to roll both amendments into one. Without objection, we'll vote both amendments into one. And sponsor, you're recognized on House Bill 2434 as amended.
All right, thank you. I think we've got our technical errors corrected on this. And what this bill does is it provides that an entity is not liable in a class action lawsuit resulting from an event resulting in unauthorized access to or disruption or misuse of an information system or non-public information stored on an information system unless the event was caused by willful or wanton misconduct or gross negligence on the part of that entity.
Very good. And I got two people here that wishes, actually one person that wishes to testify, Mr. Jim Higgins. Jim Higgins is, okay. All right, do we have any questions? Seeing none, we're voting to send House Bill 2434 to civil full. All those in favor signify by saying aye. Opposed, no. Civil full.
Thank you, Chairman and Committee.
Thank you. That brings us to item number 20, House Bill 812 by Representative Barrett. We got a motion and a second, and Representative Barrett, I do show an amendment.
Yes, Mr. Chairman, I do have an amendment. I have drafting code 013999.
That's what I show. We got a motion. Do we got a second? We have a second. We're voting to add 13999 to House Bill 812. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Representative Barrett, you're recognized on the bill as amended.
Thank you, Mr. Chairman. House Bill 812 is something that Leader Jack Johnson and I have been working on regarding the Tennessee Public Participation Act that was introduced into the General Assembly in 2019 to address the issue of SLAPP suits or strategic lawsuits against public participation. Recognizing that SLAPP suits were tactics sometimes employed to silence critics by imposing significant legal defense costs until they relent in their criticism, the current law was designed to mitigate those challenges. However, the law we passed has proven to be overly broad, resulting in the dismissal of legitimate defamation cases and denying victims access to justice. This bill aims to rectify the imbalance that was created by that law by granting courts more discretion and ensuring that plaintiffs in defamation suits have fair access to the legal system. The bill specifies that libel, slander, or intentional infliction of emotional distress are not protected forms of communication under the Act. It clearly defines a public official as an elected individual or a candidate for election in Tennessee, with communication about such officials being protected by the Act. This bill extends the time for plaintiffs to defend against an anti-SLAPP claims from 5 to 30 days, and currently judges have no discretion regarding anti-SLAPP claims and must award court costs, attorney's fees, and other expenses. This bill grants discretion to the court in these matters. And with that, Mr. Chairman, I stand ready for questions.
Representative Parkins, you're recognized.
Thank you, Mr. Chair. So in layman's terms, what does the bill do?
And y'all welcome to talk back and forth.
Thank you, sir.
Thank you, Mr. Chairman. In layman's terms, what we've seen in the court system with this particular act is it's been kind of used as a bludgeon to just stop cases in their tracks. And this is going to change the procedural aspects of how the cases are actually heard in the court. Right now, for instance, the way the law works is a defendant in a defamation case can file this suit
with only 5 days before notice before a hearing on that, and get that case thrown out. So this is going to extend the period of time for responses to that. Also changes some of the definitions. So I think we're trying to get back to what was intentionally or originally intended with the law when it was passed in 2019.
Yeah. So if you will, give me an example of, what happened, and then give me an example of what we're trying to fix.
Sure.
So, yeah.
Sure. So you have a situation where you file a lawsuit against someone, an elected official or a public official files a lawsuit against someone claiming that they've defamed them or made some defamatory comment. And that defendant would turn around and hire an attorney that files a countersuit or a counterclaim against that person under this suit, which shuts down the entire case. They can't move forward with any discovery. They can't do anything until that countersuit gets handled. So it stops the case in its tracks. And so what we're seeing is it's being used, like I said, instead of being used as an affirmative defense, which I think is what was originally intended, it's being used as an offensive measure to box people into a corner and causing all sorts of issues in the court system.
And this bill would fix that.
Yes.
Okay. And how does it fix it?
So
And
what?
thank you for your explanation.
Sure. Sure. So it defines what the bill can be. It changes the definition of what the law can be used for. And then it also changes procedurally how it works in the court. Because right now, the way the procedural rules work, it's really advantageous to the defendant to bring this suit.
Okay. Thank you, sir. Appreciate it.
Members, any other questions? Representative Bolzo, you're recognized.
Thank you, Mr. Chairman. Thank you, Representative Barrett, for bringing this. I've got just one question regarding the definition of public official. It's defined here, obviously, as an elected person or a candidate for election. Is the import of that new definition simply that a SLAPP suit can only be brought against someone who is either an elected person or a candidate for election?
Yes.
So as I understand the statute currently, there's a concept of something called a limited purpose public official. Does this revision do away with that concept in the statute?
No, Representative Bolso, I don't think so. We're only changing or providing a clarity on that definition. And I think the main purpose is to add in there that a candidate for elected office is also included as a public official.
So does the bill make any change with regard to who qualifies as a limited purpose public official against whom the anti-SLAPP statute can be used?
I do not think it addresses that. No, sir.
Thank you.
Thank you. And I do not have anybody else on my list. So without objection, we're going to, Leader Lambert, do you have a question for the sponsor?
Chairman, I know we're tight on time, but look, these have come up in my district. Do you have any idea, just roughly how many of these occur each year?
Off the top of my head, I don't. It's a relatively new phenomenon. And what we're seeing, particularly here in this judicial district that we're in, is it's become something that's being used as a bit of a weapon. And so I think that's what we're really trying to do, is to level the playing field a little bit, because this is being used to just shut down people's ability to defend themselves and defend their reputation. And so we want to make it sure that we give the ability for folks that are defendants in those cases to clap back on folks that might use the court system in the wrong way. But at the same time, it shouldn't shut down a case in just without any further discussion or debate. So.
And Mr. Chairman, if you want to, I know we're running close on time. Just when we get to the point where we're just kind of out of time for questions, just let me know and I'll cut it off and we can follow up afterwards. But how much more time do I have?
We're about it right now.
Oh, that's okay. We'll follow up afterwards with any additional questions I have. Thank you, Mr. Chairman.
Thank you. And members, without objection, we're going to vote to send House Bill 812 to full committee. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full. Congratulations.
Just under the wire. Thank you, Mr. Chairman.
Yes, sir. And members, we're out of time. So without objection, we'll roll the remaining of the calendar to next week's committee meeting. We are adjourned.